Hi, everyone. Welcome to this week's weekly live immigration attorney chat here at Immigration for Couples. I'm attorney Megan Pastrana, and it's great to be with all of you again this week. If you are new to our channel, new to our firm, Immigration for Couples, on our team, we are dedicated exclusively to helping couples across the nation and across the world and navigating the U.S. immigration process. And we have created a free resource center at immigrationforcouples.com because we know how important it is for you to have clarity and support in your immigration journey, whether you're just starting out or you're in the middle of your journey. And so that's also why we host these weekly live chats. And I see we have a lot of individuals here with us live already. And I am trying Instagram again. And so Julie will help me make sure that Julie is our firm administrator and she's here with us today. And so she will be posting some of the links that I mentioned in the chat. And she's also going to help me make sure that I actually got Instagram working this time. I had done it last weekend. It said I was live. So if any of you happen to be watching on Instagram, please let me know that that's where you're watching. And I see we have a bunch of comments coming in, that there's a lot of questions here today. So that's great. I do have one question that came through. Someone had contacted us on our social media and let us know that their question is about K2s. And so I'd like to start with that question. And for those of you who are here live, continue throwing your comments in the chat and I will get to those questions. Oh, and please, wherever you are in the world, please let me know. Where are you at currently in the world? I love to see where everyone is from. And that's one of the wonderful things about our work in the world is we get to work with couples literally all over the world. And good morning. I see we have some of our regulars. Lisa, great. And you changed your photo. That's awesome. I hope you had a good time. I think you said you were at the beach in Florida. So I hope that that was awesome. Good morning, Ed. It's great to have you here again. Again, please. Good morning. All right. You're in we have a Texas. We have somebody from Texas, someone from Michoacan, Thailand, Philippines, Germany. Oops, Germany. Turkey. Awesome, awesome. Keep them coming. Let me know where you're at in the world. All right, but let's go ahead and I'll start with that topic that we had, like I said, that we had a question on. And I see we have a heart too. If you want to like and heart this video, that helps to share it more widely. So thank you for doing that. And I see we have a lot of people here with us live. All right, so the question that we received on social media was about K2s. So the individual was asking about K2s, specifically, what are the requirements? What is the age of the child? Because this individual said they're reading online that there's reference of age 18 and then reference of age 21. So what is it? And with a K2, the requirement is that the child enter the United States before age 21. So at that time, you're a young adult, but that you enter the United States on a K2 before age 21. So that's one of the considerations that individuals who are going through the fiance visa process, if they have children that are older, over 18 specifically, but are still under 21, then the fiance visa is typically the best option to allow those children to be able to come with the fiance to the United States on something called a K2. All right. So thank you so much for your question. I know there's always a lot of confusion around that. All right. So we have some more. Yes. Instagram is working. I did it. That is awesome. All right. I've been playing with it and cool. And I see we have some individuals here on Instagram too. Awesome sauce. I love it. All right. So where else is everyone at? I have someone in New York, South Florida. Good morning from Florida. Awesome, awesome. All right. So I know I had some individuals who were in here right away this morning with questions. They're anxious. So I answer questions in the order that I receive them. I do need to end at 11:30 today, and I will do my best to answer as many questions as I can before we end. And then we will host this weekly live chat again next week, Tuesdays at 11 a.m. Eastern Time. So good morning to you, and you are very welcome. It is my pleasure. I love my work in the world, and thank you for being with us. Good morning, Jan. All right, and I think you had some questions that I saw in there as well. All right, so let me jump in here. Our case was sent to the NVC on April 16th, but we didn't take the NOA2 and other notifications from the US Embassy. Is there any waiting time for this? I'm not entirely sure I follow your question. So if your case was sent to the NVC on April 16th, I'm not sure if you have a spouse visa or a fiance visa. If it's a spouse visa and it was sent to the National Visa Center, there's an online process that you will complete. If it is a fiance visa, your case will go to the National Visa Center for a case number assignment, and then it's the National Visa Center's job to move your case over to the US consulate or embassy where your interview will occur. Okay. And so if it's a fiance visa, you're waiting on an email from the US Embassy or consulate with next steps. All right. Let's see. And then my next question. So good morning. Good morning, Anne-Marie. So good morning. Here's my question. Is there a way to delay green card processing between step 1 and step 2 of DS-260 with form I-864 you're filing from abroad? So I think you're asking if there's a way to like intentionally delay it, maybe because of a move. And so we do this all the time for our clients. If they aren't quite ready, maybe they're finishing school or a job or something of that nature. It really will depend on the country too, because some countries just have a very long wait time for the interview. So you don't need to create any kind of delay. If you're trying to get financials around, I mean, there's a number of reasons that you may want to do this. But after the spouse visa, that very first step is filed and it's approved, it will go on to the National Visa Center. And then you need to go through that process, like you're saying, that online application, that consular application, that DS-260 and your forms, and financial evidence and many other things on that list. And you have legally, the National Visa Center requires that you take action within a year, or they will close your entire case and you have to start from the beginning. There is a way to keep your case alive and ask for extensions as long as they're in good faith. But in general, you have a year, but do be sure to maintain contact because they are serious about their 1-year deadline and they will close the case if no action has been taken. So I hope that helps answer your question. All right. All right. Good morning, Lisa. And then let's see. So Daniel, yeah, I remember your question. You had a question from last week about proxy and remote weddings. If the wedding is unconsummated, I understand you can file a K-1 visa. How much about the marriage should be included in the K-1 petition? So if you were married, if you got married and you have a legally binding marriage, then the fiance visa isn't available to individuals who are married. If you're in a position where you completed that virtual marriage and you haven't been able to meet in person, you have a bit of a more complicated situation, and there are possible options. I would want to talk with you in more detail about your situation and a consultation and brainstorm some possible options. But the short answer is if you already are married, then the fiance visa isn't an option because you have to show in that fiance visa application that you are not married and you're legally free to marry. So that would be a really unique situation if that is the situation that you're in. Hopefully not, but hopefully you're just throwing some questions out there, some hypotheticals to understand. But that is the requirement for the fiance visa, is that you are not married. Okay. Okay. So for the K-1 visa interview, what's the best answer if you are asked if you plan to work in the US? I've seen so many opinions on this. Well, the truth is always the best path. I always tell my clients it's extremely important. You need to be honest with immigration. So with the fiance visa, the fiance visa has immigrant intent, which means you can come to the United States with the intention to work and live, because that is the intention that immigration is looking for you to have with that visa. And there is no right answer to that question. If an immigration officer would ask you that, it's not going to go directly to eligibility of that visa. They might just be curious about your plans for the future. So you're legally able to work once you go through that fiance visa process, and then once you come to the U.S., you'll need to be able to, or you have to legally get married in 90 days and then file for your green card and work authorization. And then at that point, once you receive that work authorization or your green card, you're able to legally work, and you'll be living lawfully in the United States. So yeah, there wouldn't necessarily be a right answer, if you will. If you're asking about, if the immigration officer would ask if you're planning on engaging in unauthorized work, that's unlikely of a question. That's unlikely that question would come up. But in general, if you plan on working once you have your work permit and your green card, there's nothing wrong with that. All right. Okay. So if someone needs a medical waiver, are they still eligible to do an adjustment of status? So I'm guessing maybe you mean like a vaccination waiver, or that it's called an I-601 waiver. So if an individual needs some kind of waiver, they can still be eligible for a green card, and they could still be eligible for adjustment of status. The question really becomes, what is that ground of inadmissibility, and is there a waiver available to overcome that individual's issue or prior history? So there are certain things in immigration law that there is a way that you can file a waiver and ask for forgiveness. And until that waiver is filed and approved by immigration, the individual cannot receive their green card. So yes, it's still possible. We've helped many individuals going through the adjustment of status process with all kinds of different types of waivers. And we have to file the waiver and get the approval. And from there, then the individual can complete the process and receive the green card. All right, so great question. Okay. And then Jan, you had a couple questions. Your picture is hilarious. That's awesome. So you're an American and your fiance is in Thailand. We applied. You completed the K-1 petition, and I'm guessing you mean the DS-160. And you have your number for the Bangkok. That's good. You have your medical and your fingerprint. Looks like you have everything done, and you have your interview on July 18th. So congratulations. That's awesome. Okay, so do I need to submit an I-129F? So let me see. You have a lot of different parts to your question. We are planning on getting married in the US, and we do not want to live in the US. And you don't want to go through the 2-year stay for the green card. You want to return to Thailand before the 90 days are up. Okay, yeah. Your question makes sense. And is it the fiance visa process? So it sounds like you have not filed the petition, and that very first step is required for the fiance visa. So I'm not sure if you're trying to get a tourist visa, but the issue becomes that when someone is engaged or married to a United States citizen, it becomes more difficult to obtain something like a tourist visa, because when you apply for a tourist visa, you have to show that you don't have immigrant intent, that you don't have intent to come and live in the United States. And I know it's most frustrating for couples who you really don't want to live in the United States. You just want your fiance to be able to come, and it sounds like maybe visit for a short time. So to be clear, the fiance visa is a process where you have to start with that petition, and part of that petition is proving that you have the intention of getting married, and that intention is to live in the United States. And after that petition, that I-129F is approved, then you would go on for the consular interview and actually receive that K-1 fiance visa to come into the US and get married. So it's again, you kind of have one of those more complicated, I guess you could say, situations where, like I said, the tourist visa is really the option for individuals who want to come for a short amount of time. The fiance visa is not the proper tool, not the proper vehicle. But then it becomes difficult, I know, and frustrating for couples who really aren't wanting to live in the US. I'd be happy to speak with you both in more detail about your situation during a consultation. But yes, to answer your question, the fiance visa process does require that petition at the beginning. All right. Okay. Hi, Harvey. So you said you spoke with me in a consultation last month about my Canadian wife's U.S. spousal visa. It was approved. Congratulations. That's awesome. And then can she activate it and stay in Canada for more than 6 months without causing issues? Thanks. All right. So once an individual receives their green card, one of the requirements or responsibilities of holding that green card is that you're living in the United States at least half the time, and that you are not taking trips outside of the US for more than 6 months. If you need to take trips in excess of 6 months, in excess of a year, you would need to file something called a re-entry permit. Because if you don't, what can happen is if you're gone too long, immigration will consider that that individual has abandoned their green card status, has lost, has basically given up their green card, relinquished it. So very important not to take trips outside of the United States more than 6 months. When you receive the green card, there is always a paper or, it's a paper, it's a slip that also goes over your rights and responsibilities. And on there, one of those things is about not taking trips more than 6 months. Tiny letters, of course, right? The important things they hide. But definitely read through that, and you can read that on the USCIS website, and then the steps that you need to take if you do need to be gone longer. So please, if you worked so hard, for anybody who got into the finish line and got your green card, don't lose it by taking trips more than 6 months. That always breaks my heart when people reach out at that point. So, all right. Thanks for your question. Okay. So, good morning. Which is a better route, diversity visa or CR1, especially with legal burden? So, diversity visa is such an interesting option, and the cool thing with the diversity visa is you really could do both. You could file for the diversity visa. It's really like a lottery, essentially, and then the spouse visa, you could do both of them. I always would say the better route would be a spouse visa route, an immediate relative route, because the reason being is there's no lottery component. There's not really that discretionary luck of the draw component. The spouse visa is very clear. These are the eligibility requirements, and you do have to prove your relationship and your love is real. That is the piece that is discretionary, where the immigration officer is looking at that piece. But as long as you're in love, as long as you have evidence to support your claim, an immediate relative, a spouse visa option is always a better path. But you could do both. All right. So let's see. My husband filed an I-130 for you and your daughter. Our cases were sent to different service centers. Yes, that's normal. It seems nonsensical. So much of immigration is. And what is your opinion on filing the K3 to speed up the process? Great question. And I just made a bunch of videos last week, and they'll be posted soon here in the coming weeks on Facebook and YouTube and all of that good stuff. And K3 was one of the topics. So the K3 was created by Congress as an option to help reduce the amount of time that couples would spend apart who go through the spouse visa process. It was meant to really mirror the wait times that fiance visas, because those historically have taken less time than the spouse visa, and they're getting there again. We're seeing wait times decrease. And so what we used to do, and I'd say prior to like about 2016, was really one of the last times I even have seen a K3 visa be approved. But you would file your spouse visa and then the K3. And then I like to, in my mind, I don't know why, but I think of it as like a horse race. And both of those applications are pending, and you wait to see which horse gets to the front of the line first. And that front of the line is an officer to review the case. K3s are almost really never approved because the wait time is about the same as the I-130, and you have to file it after. And so really immigration is just approving the I-130s still, because the K3, unfortunately, it was a great idea in theory, but in practice, it really has not been a fruitful endeavor. So unfortunately, and we've even tried filing them for clients, letting them know it was a Hail Mary pass, and we have not seen any of them be approved. It's always the I-130s that get approved before. So great question, though. It's a really interesting aspect of immigration law, and I know immigration is all of us immigration attorneys are in their ear giving our feedback all the time at stakeholder events. And so that's one of them, is either hurry up and decide the spouse visa cases faster, or start making the K3 be the fast option that you intend it to be. So great question though. All right. So yay. Awesome. Yep. That's great. I'm so glad it's on Instagram now. Okay. So it looks like, yeah, and I can see we have individuals on Instagram joining. So that's awesome. I'm really glad. Okay, so good morning. The office regrets to inform you that it is unable to issue a visa to you because you have been found ineligible to receive under 221G. Yes, and that's common. That's the area of the law. That is the same piece of the law that will be given to anyone who's been refused. And your case has been returned to the National Visa Center with a request for revocation. And so you are asking in a separate part of your comment if I could explain this. And so, you know, I regret to hear that as well. I know that's not something that you want to receive, that it can definitely cause a lot of stress and anxiety. The reason that a case can be sent back. So actually, let me back up a little bit more. The immigration interview that an individual has is at the U.S. Embassy or consulate. That interview is very, very important. That consular officer gets to have the very final decision, and they are often much more meticulous and strict, and they are really looking at the letter of the law and looking at that case with an even closer eye than USCIS. They leave no stone unturned. They do have a very extensive investigate and a fraud unit rather, and a department that does investigation work. And if that consular officer determines for any reason that they believe that, and I'm not saying this is your situation, but if they were to believe that an individual didn't have a bona fide relationship, or maybe there was a prior marriage that someone thought actually that divorce was final and accurate. I've actually seen in other countries, because of record keeping or for whatever reasons, that divorce actually hadn't been finished. So the person really wasn't legally free to marry. And then they get one of these notices and they contact our office, and then we help them to figure out what that issue is. And so I know you're asking for me to explain. Basically, they have found something in the case that says you're not eligible. Is there an option to overcome it? Possibly. Maybe you need a waiver. Maybe there's something that needs to be remedied so you can refile. I would definitely need to speak with you privately and a consultation, and we would be able to talk about next steps and what that revocation might mean and what we can do proactively. So you're welcome to schedule a consultation. Julie can put that link in immigrationforcouples.com, and you can schedule a consultation with me. And then there's a way that you can send documents by a secure link for me to look at as well, so we can talk about it. All right. Again, I'm sorry to hear that was the response that you got. Yeah. I know that's a rough response to hear from immigration when you've been waiting so long, but they are telling you that your application's taking longer than expected. You're probably seeing that on your online portal, and because immigration is putting on that online portal for certain case types an estimated wait time, and they're putting the wait time that they're striving for. They have these internal goals that they want to adjudicate cases in a faster, more expeditious manner. And they're not reaching those goals. So then when they get down, the clock gets down to the end of that goal, that estimate, then it turns to it's taking longer than expected. So typically waiting, you have to continue waiting. In some situations, though, where individuals, like for an adjustment of status, for example, if someone's been waiting for more than 12 months on an adjustment of status, our office files something called a mandamus action to basically sue immigration to do their job. That sounds crazy and extreme, but we have to do that a lot, more than you would expect. So it depends on your case type, but in general, that's normal. You just have to keep waiting unless it's one of those situations, an adjustment where it's gone way beyond that wait, that 12-month wait. All right, I can do one more question probably. Yeah, as you were asking that question, that I think you were on since the beginning, and so you saw me answer that question for someone else about the K3s. It won't necessarily help with the processing of the spouse visa application. It's a good idea in theory, but typically it's two different offices, and it really just matters which application gets to the front of the line first. It might give you a sense of control to do both, and if it does, then you can do that. But yeah, unfortunately, those K3s, yeah, didn't get to actually be used for their intended purpose. All right. Let's see. And so Jesse, my fiance and I were approved by USCIS on April 3rd of 2024. Oh, yep. And that is very common to not receive that welcome letter. You can always reach out to them on the inquiry portal. We do that exactly at the 30-day mark here for all of our clients to kind of push that along. So it is very normal. They used to say it would take 60 days, and it was taking them more like 90. They are getting closer to about 35 days, but you can always reach out to them and kind of poke them and say, hey, it's been 30 days. Do you have my case number? So doesn't hurt to do that. All right. I do have a couple more minutes. Let me see. Because I got on a little later from all of the tech stuff, trying to get Instagram set up, but that was a successful endeavor. So I have a couple more minutes to answer a few more questions. We had an estimated 6 months before decision. Now it says taking longer than expected. Very frustrating when there's no way to contact anyone. Yeah, that is the frustrating part, when you can't talk to someone and just know that, do you at least have it? Is it in the stack somewhere? Like, is an immigration officer going to review it in a few days or a few weeks? It's the unknown that's always uncomfortable in life. But think about you are one day closer, and you'll have a decision sooner rather than later, hopefully. But good luck with your case. So we have a few more people who told us where they're at in the world. So we have 2 Canadas. That's awesome. A UAE. That's great as well. And Ohio. All right. Okay, yeah, great question. I think I've received a question about remote work almost every Facebook Live for the past few weeks. So this is a hot topic. So you're working remotely for a U.S. company for 4 years now. They send my pay through a bank account in the Philippines. Am I expected to resign from my remote job while on the K1 visa? So with all of our clients, we have to go through a very fact-based analysis of their particular situation to ensure that working on that fiancé visa remotely is in compliance with the law. The thing about remote work that is maddening for a lot of couples, for a lot of individuals, is that immigration law, it's really a gray area. Why is it a gray area? Well, because when the laws about unauthorized work in the United States, when those laws were written, it was well before remote work was even a thing, even a reality. That had not even been contemplated by immigration when the law was written. So that's why it's a gray area, and that's why it's going to be really fact specific, and it's really going to depend on your immigration officer who reviews the case. In general, when you're here on the fiancé visa, you're not able to work until you receive a work authorization. Remote work is something where if the remote position is not for a US company, if you're not receiving pay in the United States, depending on whether or not your location matters, there's a whole bunch of factors and things to consider as to whether or not that work would ultimately be authorized or unauthorized. Unfortunately, I can't tell you conclusively without knowing more about your case and more about your situation and the history of your work and the type of company and where the headquarters of the US company is, and if they have a headquarters in the Philippines, and what your paycheck says and what type of job. I wish I could give you a conclusive answer, but this is one of those gray areas. If it is a US company, though, that leads me more to you're in an area where an immigration officer is more likely to say that that's not allowed. If you would like to discuss that more privately, this is what we would need to do in a consultation. We can definitely do that and talk through your situation, and I can give you more customized legal advice. I can't tell you conclusively here without knowing more details. And it's also important to know too, I always tell couples the law is always changing, and it's a gray area that's going to have leave a lot of room for interpretation on that particular immigration officer. All right, so great question. It's a popular question, like I said. I have 2 minutes. I think I can do one more here. Okay, let's see here. Okay, so Pierre, you wanted to know, I was going through some hellos and things like that. I found your question here. What if my wife is in the immigration process and I need my wife to visit me? Yes. So if you're going through the immigration process, a spouse visa, I'm assuming, then if your wife has some kind of tourist visa or ESTA, that would allow her to come for a temporary visit while that application is pending. Every entry is discretionary, which means when you're entering the United States on that tourist visa or ESTA, that immigration officer is going to look at what is your intent. Are you truly coming to visit? If your wife doesn't already have some type of authorization that allows her to come and visit the United States, really visiting is something that's not possible. And sometimes in some emergency situations, we've been able to get a one entry tourist visa or a humanitarian parole and things of that nature. But in general, if she doesn't already have a tourist visa or ESTA or something of that nature to visit, it's typically not possible. So all right. So the time flew by as always. I see that we still have a lot of questions, so that's great. We'll take a look at these, and I can answer some of these topics at the start of the Facebook Live next week. But I would just encourage you, please all join us again next Tuesday at 11 a.m. Eastern time, and I'm happy to go over more questions then. So thanks everyone for being with me today. It's a pleasure to be with all of you. Good luck with your immigration cases. I promise you'll get to the finish line eventually, and have a fantastic week. All right. Take care, everyone. Bye.